This is good morning, my lady. I appear for the applicants in this matter together with my friend Mr. Mwela and Ms. Ndabu. As God pleases, my lady.
As your ladyship pleases, and good morning, my lady. Together with my learned friends, Mr. Salugazana and Mr. Njokweni, I appear for the respondents.
Of the heads. My lady, I might have, ironically, I might have a spare copy of their heads and not mine. But so, let me just check. Let me just see if it's unmarked. Yes, I do have an unmarked set of the respondents' heads, my lady. Let me just check. Yes.
My lady, we're both looking at the same authorities.
Oh, okay. You know, I think the one, I have two. One has got the case line. I'll give you a ladyship the one with the case line references.
Don't worry about it, it's fine. I have them, I've read them, it's just to actually in this one.
Well, now, if your ladyship wants, I'll put them here. Thank you.
We have a hard copy of ours.
We have yours as well.
Oh, we do, my lady.
Looks like we have both, my lady. It might be convenient for your ladyship to have.
Thanks.
Just not stapled, my lady.
That's fine. If they're punched, I can put them
Yes,
in
if
this
they're
very
punched.
nice, expensive file that I've been provided.
That's too much. It's too big. Thanks. It's true. It's the applicants and the respondents.
As God pleases, my lady. My lady, as just one of the few housekeeping matters is that it looks like there's some confusion in the case lines numbering. It changed. I also prefer to use the hard copies, but my learned friend tells me that some of the numbering has changed. So if that problem...
Everything's been uploaded nicely with separate annexures. So
Yes.
we can just click on the right annexure.
Yes, my lady.
We can refer to things by their name.
Well, absolutely.
And
As God pleases. That's what I was going to suggest. We'll refer it by paragraph and names and then maybe supply
but
the
I've got the
pages.
hard copy also, so
That's-
let's be old. What do they call it? Old school.
Old school, yes.
Right.
For the sake of Mr. Mukta. Some of us are more modernized. Thank you, my lady. My lady, the other housekeeping matter is that we, as your ladyship might have noticed, we were served last night. Our learned friends specialized by overnight service. We were served last night with a supplementary affidavit. Yes, my lady, we have looked at it. We have no objections to its being accepted for the sake of progress, and also because we actually are of the view that it is helpful to us.
Well, Mr. Mpofu, in my view, it doesn't contain any factual matter.
Doesn't?
So, as an affidavit, I'm not sure how helpful it is.
Yes, maybe it
but,
should have been supplementary heads. Yeah,
But
that's
if
that's
you
really
have
what
no
it is.
objection, it's there, and we admit it. Before you carry on, I heard someone's phone make a noise. Please, can everyone make sure that their phones are on silent? Thank you.
Thank you, Madam. Right. So, my lady, let's start at the beginning. We say in our founding affidavit, my lady, that it is important to explain what this matter is not about. And we said that really to try and avoid some of the unnecessary technicalities that might arise. But it looks like that did not really assist much. So I have to just re-emphasize what the matter is not about so that we don't get waylaid into unnecessary debates. Well, my lady, this matter is particularly contrary to popular belief. It's not about the GNU. It's about the SABC and about the constitutional obligations of a public broadcaster, which is an organ of state and which is not just an organ of state, but one of a special type. The mere fact that it so happens that this organ of state that we're talking about deals with or operates in the media space is for the purposes of the law, that's a coincidence. Could have been an organ of state that deals with electricity or whatever it is. The product that this particular organ of state produces is of no major significance from a legal framing point of view. In other words, my lady, the rights that we want to enforce qua organ of state are those rights that reside in Section 33 of the Constitution. But as far as the so-called declaratory order is concerned, then it's the other rights, so whichever Section 9, Section 10, Section 12, and so on, 19 of the Constitution. The other issue, my lady, is that this is not a case, unlike the cases like TAC, Grootboom, and so on. This is not even a case about so-called second-generation rights. And that strengthens the case, because if the courts could entertain so-called second-generation rights, which they should, then how much more about a case that deals with first-generation rights, such as equality, dignity, political rights, and so on and so on. So it's important to keep that at the back of our mind as we deal with this matter. But most importantly, my lady, since the issue of urgency has been raised, we want to put it plainly that that issue really should not trouble the court very much, because the opposition is at best contrived and unfounded.
But Mr. Mpofu, it troubles the court whether there is opposition or not.
Yeah, well, that's exactly why I'm talking about it, my lady. Yeah. And because it really shouldn't, my lady. The point is really at whatever level it really shouldn't feature. Particularly, as they say, because if one take it from whence it comes, at least, which is the respondents that have really abused, in the most extreme sense that I've ever seen, the processes of this court. So it really doesn't lie in the mouth of a respondent that just sat with documents for a whole month and did nothing, to now come at literally on the eve of the hearing and say, oh, it's not urgent. They actually took longer than the normal Rule 6 days that are allowed in normal applications to even come up with the so-called answering affidavit. So, just in terms of the clean hands doctrine, it's not for them to just sit. I'm not exaggerating. Actually, I've never seen anything like that, where somebody gets papers and urgent papers for a month and does nothing, and then the day before the hearing, kind of wakes up from their slumber and say the matter is not urgent. Maybe it just happened to other people. It just never happened to me. But be that as it may, my lady, even if they had not abused the processes of the court, the point is the following. 4 particular points are important. One is that we are dealing here, and the respondents should know better, my lady. We're dealing with the most egregious and serious rights in the hands of the citizenry, not of one person. Most of the cases before your ladyship here would have involved one person or another getting evicted or whatever, or in some place or another. Here we're talking about, on their version, millions and millions of people who, according to the allegations in the papers, are being poisoned, and I use that word advisedly, on an hourly basis, on an ongoing basis, as we speak. In other words, as we're sitting here, this is happening. Now, you know, there's a tendency, I think it's just a human factor, that maybe we take seriously the things that you can see and touch. So you can poison people's minds, or rather, but you can't poison them by actually feeding them poison in the mouth. If you do that, then it's urgent. But if you're poisoning their mind, it's fine. But it's the same thing. The fact that it's not tangible.
I'm sorry to interrupt you.
I'm sorry.
Please.
Yes.
Phones and computers on silent. And if it happens again, I'm going to adjourn.
Yes.
And you're going to each find your phones, and the person whose phone is not on silent, Mr. Mpofu and Mr. Motao, are personally going to make you leave the court.
we are available.
Thank you.
Thank you. So I'm saying, my lady, if I was coming to your ladyship here, let's just take a small example, and I said, my lady, in some school or hospital, somebody is actually being administered with poison. The ladyship and Mr. Mutao would say, well, that's obviously urgent. But if I'm saying millions of rural people whose only source of information about participating in this democracy is the SABC, are being fed with propaganda on a daily basis, then we say, no, it's fine, we can deal with that next year. That is, my lady, the long and short of what we're being told here. Because that's what in due course means. You know, we churn out all these nice words in due course. But in due course in this context means next year sometime or even the year after. So it's fine, let it continue. The most important thing, my lady, is that this court in Apleni, and we deal with Apleni in our heads of argument 29. Paragraph 29 of our heads, my lady. Again, a situation that is, by comparison, far less serious than what we're dealing about here. I happen to know Mr. Apleni, and I was almost in that case of his. But with due respect to him, whatever harassment he was receiving from a minister or another, it was his problem alone, not a problem, not even of the Department of Home Affairs, but of his, let alone millions of people. And the court, this court said in this division, where such allegations are made relating to abuse of power by a minister or other public officials, which may impact upon the rule of law and may have a detrimental impact upon the public trust, the relevant relief sought ought normally to be urgently considered. Now, in other words, I know my learned friend doesn't like the word inherently urgent, but that's what the court was really saying. Was saying that in those kinds of circumstances, which are, as I say, negligible, often negligible impact compared to what we're dealing with here, the court at least ought normally to urgently consider such abuses. And it should be so, my lady. In fact, we should not even be having to debate this. There's another case called Prince Law. I'll get it's a 2004 case, I'll get the citation number, where Justice, I think, Van der Vesthuizen in Pretoria said the same thing, that where fundamental rights are impacted to the levels that we're talking about here, it's an anomaly to say that the matter is not urgent. So that's the first thing. The second thing, my lady, is the rule that my learned friends deny or question, which is that for the purposes of urgency, your ladyship has to assume that our case is as it has been pleaded. In other words, that the violations that we allege have happened. When we come to the merits, your ladyship might well find the opposite. That's a different story. But for the purposes, and that happens in any point in limine, by the way, if you're talking about jurisdiction, and Justice Nugent tried to explain this ad nauseum in the SCA, in the case of Makanya, that when you're talking about jurisdiction, for example, you are not asking whether that party is going to win or lose. You are simply saying, does the court have jurisdiction to make them lose or win, as it were. So it's the same with urgency. For the sake of urgency, you have to assume that the allegations on the merits are true. You have to, if we're saying 1,000 people are going to die tomorrow, for the purpose of urgency, you have to assume that that is so. It might well be that when you come to the merits, you'll find it's only 100 or whatever it is. That's what is said in paragraph 75 of Taba. That's a simplification of that where the court said jurisdiction is looked at from a point of view of the pleadings, what has been pleaded, so this is what was said in 20th Century Fox by this court a long time ago. Goldstone J said, and you'll find that in paragraph 31 of our heads, my lady, for the purposes of deciding upon urgency, I assume, as I have to do, that the applicant's case was a good one and that the respondent was unlawfully infringing the applicant's copyright in the films in question. If you transport that to this matter, for the purposes of urgency, you have to assume that the SABC, a public institution, is transgressing and violating the rights of the citizenry of this country, 60 million or whatever the number is, on an hourly basis, on an ongoing basis, and as we speak. Now, if you assume that as the law compels you to do, how on earth could that then be termed ordinary and it's fine? They must just deal with it, those citizens. You know, we are busy with evictions and all sorts of other things which are much more important than them. Really? And my lady, you for the purposes of this argument, your ladyship must not listen to me. Listen to the other side. This is one of the case cases, they quoted paragraph 27 of their heads. I'm sorry, page 27. Paragraph 56. They say, quoting Kumalo on page 27, in a democratic society, the mass media play a role of undeniable importance. They bear an obligation to provide citizens both with information and with a platform for the exchange of ideas, which is crucial to the development of a democratic culture. Crucial. As primary agents of dissemination of information and ideas, they are inevitably extremely powerful institutions, maybe even more powerful than the police in a democracy, and they have a constitutional duty to act with vigor, courage, integrity, and responsibility. And then it goes on. So, on the version, not of ourselves, but of the other side, we're dealing here with one of the most crucial institutions that deal with citizens, with shaping the very democracy that we live in. In fact, one of the writers said that whatever your primary issue is in life, your second one better be the media, because whatever that primary issue, if it's distorted by the media, then so your primary issue could be animal welfare or whatever it is. But if the media portrays it in a particular way, then you might as well kiss that issue goodbye. But my lady, we have quoted just as a last. You'll find that in paragraph 2, where we've quoted this book by, it's a book called The Future of the Media, Resistance and Reform in the 21st Century. One of the leading writers in this area, called McChesney. This is what they say, and you'll find that in paragraph 2, my lord. If free and independent journalism committed to telling the truth, underline the truth, without fear or favor, is suffocated, the oxygen goes out of democracy. And there is no surer way to intimidate and silence mainstream journalists than to be the boss. Now, I want to emphasize on two things. The truth. So if you suppress the truth, or you don't present the truth without fear and favor. But here's the key word. It says you suffocate, the oxygen goes out of democracy. And to go back to my theme, so if the oxygen was going out of my Leonard Jr. in some ICU ward, then we would say it's urgent. But if the oxygen is taken out of the entire society, it's not. I mean, how can that be? So here's the summary then, my lady. One is the fact that your ladyship has to assume that the allegations are true. Number two, the ladyship has to take into account what this court has said in Apleni. Number three, the ladyship has to take into account that the allegations from the applicant side are that this is a so-called continuing wrong, which happened yesterday, it will happen tomorrow, and it's happening today. And against all that background, my lady, the ladyship must take into account that, and it's stated in the founding affidavit, that the applicant still, with all that background, went out of its way to give the respondents more than ample time to respond. And even that ample time was not taken up. Why was that so? Because we know in the real world, it's an organ of state, people have other things to do and so on. But there's nobody, my lady, who has a right to claim longer than the rules of court give you. and I don't know, but maybe the court is not offended by this, but we certainly are offended by being given an answering affidavit less than 12 hours before the hearing, when we've given them a month. So that is the most egregious abuse. So, my lady, with the greatest respect, we really should not spend so much time on this. I know that the issue of urgency is intertwined with the merits.
Yes.
But I just wanted to deal with it in an isolated fashion. When I've dealt with the merits, my lady, I will revisit to say, my lady, against this picture, how on earth can anyone say that this is a matter that should be left to the ordinary role, as it were.
Okay.
So let's move then from that, my lady, to the issue of abuse of court per se. We summarize that, my lady, in our response or reply. I think we call it. We didn't know what to call it, so we call it the response or reply to the answering affidavit. You'll find that, my lady, from paragraph 5 onwards, the case line's reference is 02-47. 677. Okay, again, I'll summarize for the sake of saving time.
Well, I mean, fully aware of all of this.
Helen?
I'm fully aware of all of this.
Yes. No. Well, I should hope so.
And
The leadership.
one might add that I'm not sure how much factual material is contained in the answering affidavit anyway. It's again argument. But leave that aside. Carry on.
So, my lady, is the suggestion that if there are no factual matters, then a person can ignore the rules?
No, I'm not saying that.
Okay.
I'm just saying that it begs the question of the value of it.
Yes. Now, let's assume it's completely valueless. But the issue of not answering to our valueless pleadings is not contemplated in the law. There's no what to call it? Quantification of the rules. Simply say you get a document and you must respond by such and such a date. Doesn't matter what you think of it. You might think.
Yes, and until the court decides otherwise, they're bound by what you've set out in your notice of motion.
Absolutely. Yeah. But I'm saying it's even worse than that, man. The Republican case. Yeah. Here, let us forget about the notice of motion. Let's just talk about the rules of court. It's just the normal rules. If they breach even that, because Republicans simply says what we put in the notice of motion then assumes the status of the rules. I'm not even using that. I'm saying just take the actual rules. And if you breach that, whatever the valuelessness of the pleadings, you can't. Firstly, you can't breach it. But if you do, because we all do for good reasons now and again, if you do, then you are bound to ask for the condonation of the court. Surely. You can't just rock up 6 months later and say, here's my answering affidavit, because your documents don't carry much value. You can't. You are bound by having to respond and as I say, at least at the very minimum, to ask for condonation. I can tell you, my lady, if it was us who had done this, if we simply just ignore them and just come up here and say no, it's their document doesn't have much, so we just decided to just walk into court. everyone will be up in arms to say what's wrong with these people. So we can't do that. And I'm not talking about one instance. They were supposed to give us the record after 5 days. They failed to do so. It was 14 days late. Did they apply for condonation? No. They were supposed to give the notice was supposed to come on the 16th, and it came 3 days late. Did they ask for condonation? No. And then the purported answering affidavit comes on the eve of the hearing. Now, that affidavit, that's why I keep on calling it the so-called affidavit. It has got probably the distinct, unique characteristics of being both early and late. Because to the extent that we're dealing with Rule 53, my lady, no answering affidavit is due, because they should have given us an opportunity to supplement. So in that sense, it's quote-unquote premature. But let's assume they don't know anything about Rule 53. They're only dealing with Rule 6. To the extent that it is done under Rule 6, then it's hopelessly late. So how can you even call that such a thing an answering affidavit? It's a schizophrenic piece of paper that doesn't know whether it's coming or going. And we are supposed then the following day to deal with that. Do they ask for condonation for that, for breaching both Rule 53 or 50 or 6? No. The court must just deal with it and live with it. That's the kind of impunity, if that is the kind of impunity that we want to promote in the courts for certain parties, then, why must juniors and attorneys follow the rules of court? Why? Because they can't just follow the lead of our rulers, the organs of state, and just ignore the court, disrespect the court. These are people who are compelled by Section 165 of the Constitution to ensure the effectiveness and dignity of the courts, unlike us normal mortals. They have a heightened duty to ensure the effectiveness of the court and the dignity. And we say, no, it's fine. Against a citizen whose only sin is to ask to vindicate their constitutional rights. Now, my lady, the reason why I'm raising this is because, as your ladyship knows, this is trite from old cases like Hudson versus Hudson. It is trite that the court may dismiss an application on the basis of abuse of court alone. That's so unlike the agency issues deals with striking a matter off the roll or whatever, but you are given a second chance. But once you abuse the process of the court, you've now gone beyond levels of striking. It's a question of why must the court, if you don't respect the court, why must the court respect you by recognizing your claim or defense, whichever side is at fault. And again, that rule has been enforced numerous times, particularly against the first applicant by this court. In a situation where the only quote-unquote abuse was that the particular process was issued and it happened to coincide with some conference of a political party, and that was said to be an abuse by this court. I'm not talking about the kind of multiple abuses that we're talking about here.
Mr. Mpofu,
Yes.
the point is made.
Yes.
Can I encourage you to get on, because it's 12:10. We are in the urgent court, and I still have another opposed matter to deal with today.
All right, my lady. Well, my lady, well, ordinarily that could even be it. As I say, the matter could be dismissed on that basis. So
Well, no, you're the applicant.
Yes. I'm saying the defense
The
could
defense
be,
could
that's
be
what-
dismissed.
Yes, the defense
But
could
I
be
still have
dismissed.
to
The answering
keep
affidavit
this.
could be ignored, quote unquote.
That's fine.
Let me put it that way. But,
Okay.
but be that as may, I hear your leadership. So let's
Okay.
now.
No.
I'm sorry.
Who is that? Okay, but whose phone is that? Please at least own up.
Otherwise, I'm going to be a snitch.
We're not going to carry on until you say who you are. Please silence your phone. Next time, please silence it before you walk in. All of you. Thank you.
Thank you, my lady. Thank you, my lady. Yes, sorry, I lost my train of thought. Anyway, so this is where we are, my lady. If we then go to the merits, let's assume that your leadership is at least satisfied that the point is made. I won't put it higher than that. Now, my lady, what is it that let's go back to what we say the matter is about. There are two. This is on the merits, my lady. Really, this should not detain the court. There are two causes of action, all simple and common and usual. The one cause of action, at the risk of repetition, is that the court must declare constitutional invalidity of the conduct that is complained of. So what is that conduct? That conduct is explained in great detail, my lady, in the factual exposition. But what is the constitutional duty? Because that's where we must keep our eyes. I assume from what I read from my that and the other. I can't remember the emotive language that was used there. Now, a broadcaster could not have agreed with him in that way and mimic or parrot what that person is saying. Because if they do that, then they are breaching the rights of citizens. I'll make another example, an international example. There are people who refer to Israel as apartheid Israel. Whether that's true or false is not the point. But a public broadcaster cannot adopt that, however true it might be. Why? Because some people in the public might not think so. and those people are human beings too, and they must be serviced. Whereas if it was a mouthpiece of the government, then it would simply just adopt that terminology. And the same thing is happening here. The examples can be endless. But the legal point is simple. The legal point is simply that the constitutional duties of a public service broadcaster do not include lying to the people or giving information that is inaccurate. And that's the key. So the legal word is accurate. That's why I said emphasize the question of the truth. So if something is inaccurate, it is ipso facto a violation of the rights of citizens. If something is not independent, it is ipso facto a violation of the rights of citizens. If something is not impartial, the best word is unbiased. If it's not unbiased, in other words, it's biased, that's a double negative. If it's biased, then it is ipso facto a violation of the constitutional rights of citizens. If it's not objective, I don't particularly like that one, but that's what it says in their own documentation. But so if it's not objective, then it's ipso facto a violation of the constitutional rights of citizens, and so on. So let's use the three terms that nobody can quibble with: accuracy, independence, impartiality. Any material that lacks one, not all three, in this case it's all three, that lacks one of those is a violation of the rights of citizens. Here we have a situation where the material violates all those three. Accuracy is inaccurate because we have shown, and nobody has denied, Malene, that at least lawyers work like this. Definitional elements, you say, what is murder? It's the killing of a human being with intention and unlawful. So once the definitional elements are not there, then you can't say something is murder or assault or whatever. It's very simple. We were all educated like that. What is this? It has these elements. If one of them is missing, then it's not that. So it is at that elementary level.
But is this one not a question of interpretation?
No. It can never be a question of interpretation. The absence of elements is not a matter of interpretation. That's a different matter. Interpretation is when you look at a document and then you say, okay, what is the meaning of this?
Or a word, not just a document.
I'm saying, or anything. A word, a book, or whatever it is, a statute, a constitution, whatever. That's you can talk about interpretation. But you can't say it's interpretation when if you say, look, somebody stabbed someone.
We're not talking about stabbing. Let's use what we're talking about.
Well, my lady, I can't make analogy. Okay, fine.
No.
All right. Definitional elements. Okay, let me go to theory then. Definitional elements of anything, whatever it is, my lady, are the legal requirements for that thing to exist. Okay, let's at least agree at the theoretical level. So, if your ladyship says, let's talk about what we're talking about here. We say there are two definitional elements, and that has not been denied. Okay, two major definitional elements of what a government of national unity is. One is that it is a government that you'll find that in and mine is O2 sorry, my baby. where we talk about the 90%. 60. Okay, sorry. Yes. So 02-164, sorry, my lady. Paragraph 60.
dash
164, my lady, or paragraph 60 of the FA, of the founding of the.
Right.
Got it, my lady? Yes, okay. That's where we deal with the first element called accuracy, or the first violation under the heading of accuracy. We say, with specific reference to accuracy, it is specifically pleaded that the current arrangements do not fit the definition, that's of definitional elements, of a government of national unity. It should not be term unity. Which term is used to describe a situation where, one, the vast majority of elected parties representing approximately 85 to 90% of the electorate, and two, that the nation in question, remember national unity means there's a nation somewhere. The nation in question has undergone a catastrophic or calamitous event calling for a united effort across the usual dividing lines, which would otherwise apply under normal circumstances. But in case those definitional elements, which are not denied, are doubted, we then go to the Oxford Dictionary, paragraph 61. Oxford Dictionary of African Politics defines GNU as, quote, one that brings together a number of rival leaders and political parties in order to promote national unity and political stability. Governments of national unity are often formed after political crisis, after a period of conflict or during a transition from one regime type to another. And then Wikipedia says it's a broad coalition government consists of all parties, that's even higher, all parties or all major parties in the legislature, usually formed during a time of war or other national emergency. So on any of those four descriptions, and it's not a matter of, it's a matter of definition really, not a matter of interpretation. On any of those definitions meanings, remember, it's like a statute where it's in a particular statute, a definition will be, let's say, car in this thing means this, that, and the other. So on any of those definitions, what is actually obtaining, which has been described in detail in the affidavit, is not a government of national unity. So let's at least agree on that simple proposition. And if it is, it's inaccurate in that sense. And if you don't have to believe us, you must believe the people who are the architects of this thing. And you'll find that in our
reply affidavit.
Reply, yes. That's for current purposes.
Where you refer to the
we refer to, yes, it's paragraph 59. Yes, paragraph 59. This is what Ms. Helen Zille, Federal Chair of the DA, says. Quote, President Cyril Ramaphosa came up with this notion of a government of national unity, which he thought would be a better way of selling the concept of a coalition to his own party. And she says, now this is of course not a government of national unity. Because, and she explains why, a government of national unity brings all the parties together. It's in line with one of the definitions I read out to your leadership. Which would have included, which would have to include the EFF and MK party, Umkhonto weSizwe party. That's the second applicant, which it did not. But still, it still gave the president the fig leaf, underline that word, the fig leaf he needed to bring in all sorts of smaller parties to say, I am not in a coalition with the DA. And then here's the bombshell. She says, now the truth is, remember the truth? Now the truth is, what we are actually is that we are actually in a coalition, because a coalition means that if a party withdraws from the coalition, the government fails. False. Sorry. Now, this is not just some Tom, Dick, and Harry speaking. This is what probably the person who attached the first signature to this thing, or authored it, I don't know, but very close to its conceptualization. She's telling us, as the dictionaries, people who don't even know where South Africa is, she's telling us exactly what they are telling us. She's saying, because, and she's not just talking, she says because this and that and the other. And she says it's a fig leaf. No, fig leaf literally means a leaf of a fig tree, where you try to hide yourself with a leaf, but your whole body is exposed. So she says it's just a deception, a tool for deceiving. Now, please, let's understand this. This is not a criticism of whatever the purveyor of the fig leaf is. President Ramaphosa is entitled to fig leaf or hoodwink his own people and so on. This is not what this case is about. This case is about whether the SABC, which is a public broadcaster, should then be the mouthpiece that mimics that deception and gives it official respectability and feeds millions of people with the fig leaf. So it's not about the fig leaver or whatever the noun is, but it's about the purveyor of the thing. So if some mad person says women are inferior or blacks are inferior or whatever, that's their problem. But the issue is about whether the public broadcaster should then be a mouthpiece for such a thing. And that's a crucial thing, my lady. It might not look, as concrete as my learned friends want us to believe. But in the minds of those that are being poisoned with this, it is more than concrete. It was Steve Biko who said the greatest weapon in the hands of the oppressor is the mind of the oppressed. So the greatest weapon is not the guns and tear gas and all those things. No. The greatest weapon is to poison the minds of people. Every war, whether it's in Gaza, whether it's in Second World War, and so on, is
of all of that.
The impact.
I have read the papers.
Yes.
I understand the argument.
Yeah.
And I understand the importance of the public broadcaster. I understand also that if the public broadcaster is in fact doing what you say they are doing,
Yeah.
then it is an ongoing harm.
Yes, thank you, my lady.
But
yes. Oh, sorry. The more important part.
yeah.
Yes, my lady, you're saying
Okay.
that part.
There's two things. Number one is we need to get on with it because there's very little time left. Number two is I'm not sure that you've established that the minds of the people are being poisoned, because as much as the SABC is the primary source of information for many people, one can't assume that just because the people are rural and illiterate, that they are unintelligent and politically unaware, and therefore susceptible to being easily poisoned by the use of this term.
No, I'm sorry. With the greatest respect, Madam. It doesn't matter. We can assume that the people are so intelligent and astute and are able to see through the so-called fig leaf. That's not the issue before you, Madam. The issue is whether an organ of state to disseminating information to these intelligence, super intelligence geniuses of people is entitled or not to give them information that is inaccurate.
All right.
That's really the only issue. It's not
The
about
only issue is whether they're entitled to disseminate inaccurate
yes.
information.
And in other words, even the attempt to hoodwink the people is bad enough. Doesn't matter if the people actually are such 60 million geniuses and that they'll see through it. The mere act of attempting to do so. So that's the first thing.
Okay.
The inaccuracy. So the inaccuracy is established. That's really the point I was making. That inaccuracy point is established. The second point is independence. Right? Now, independent from what? Independence in the world of broadcasting means independent from those who wield power. Whether they are commercial, that's commercial power, or public power, that doesn't matter. Now, we have demonstrated to you, my lady, what the genesis of this fig leaf or hoodwinking device is. The genesis is a meeting that happened on the 6th of June in Boksburg somewhere, and that's when the thing was coined for the first time by former President Ramaphosa as in his capacity as the president of the ANC. So the Genesis is a political party, a dominant political party.
Right.
But before you look into that, my lady, you have to look at this thing from the point of view of the rights of the citizens, as enshrined in section 16(1)(b) of the Constitution. And this is where there seems to be some misunderstanding between us and our learned friends. Of course, it would be foolish of us to say that the SABC, like all other media houses, is not a functionary of Section 16. I mean, we're not that stupid. But what we're saying is this, that the duty to impart information is directly proportional to the duty of the citizen to receive that information. In other words, in as far as the SABC has the right to impart information, that right, it must impart accurate information. Why do we say that, my lady? You won't find the word accurate in the Constitution, but you're going to find it where? In the statutes, in the regulations, in the editorial policies. So unless if somebody attacks the constitutionality of those statutes that bring accuracy, then you can take that word and transplant it directly into the Constitution. So the right of citizen is to receive accurate, independent, and impartial information as the framework stands now. Now, against that, my lady, this court, no, not another one, said the following. Justice Klassen, which is the thing we have on our preamble. The SABC cannot be equated with a private citizen or broadcaster who is entitled to freedom of expression. The SABC is a public broadcaster funded by the taxpayer to provide the highest standard of journalism and fair, unbiased, there's that word again, impartial and independent news coverage. Whereas a private citizen or broadcaster may freely take political sides to promote party political objectives, a public broadcaster may not use public money to do so. Now, if that is even debatable, then so that's what Judge Klassen says. Now listen to what former President Zuma says. You think that they are Siamese twins. He says exactly that. He says, you'll find that in paragraph 43 of our heads. He says, the media is also selling the story of a government of national unity when they know that there's no such thing. I know because I was part of the leadership which introduced a GNU in 1994. We have asked our lawyers to write a letter of demand to the SABC to stop deliberately misleading South Africans by using a term like government of national unity, government of provincial unity, and so on. We know that the private media has to serve its masters. That's exactly what Klassen J said. But the SABC belongs to us, he says. It has no right to feed our people with lies or to pursue narrow agendas at our expense. So what this court said and what the first applicant said are exactly the same, literally, word for word. If I read out those things and say who said what, you wouldn't be able to say whether it was Klassen J or former President Zuma. And that's the point that's missed in this case completely, about those duties of the public, those higher duties, as it were. So of course, they are like any other media, they've got obligations like other media, but as Klassen J said, they have a higher duty. And this case is about that portion, that higher duty, not the normal stuff. And if that higher duty has been breached, as it clearly has been, whatever it's like, my lady, you know, I'm just, sorry my lady, this has been bugging me, so I have to get it out of my system. This idea about the people are intelligent. So this was the defense that was given when somebody called it, I think Penny Sparrow, said black people are monkeys. So it's said, no, but they know they're not monkeys. They are people. So then, is it fine? No. The mere fact that the recipient of the pejorative violation might be able to see through it can never be a defense. So that's independent. So independence means you can't be a mouthpiece of the ruling, or these days the dominant party, since it's no longer ruling. So the end, even worse, the president, who then, as we've shown, imports that term from Birchwood, as it were, to the union buildings, and now gives it official. So that just makes it worse. It was bad enough to mimic a political party, but to then mimic the government of the day, how can you call that independent? I mean, nobody in their right mind would associate such a thing with independence. So the last one is impartiality. The impartiality, and now comes that's why we don't object to the supplementary affidavit, because the supplementary affidavit actually makes the point that we want to make even better than we are making it. My learned friends, they miss the point. So they say, no, Helen Zille can say this, and then on another day he says this, and therefore they say it's a debate. We say, yeah, okay, it's a debate. So that means the matter is a matter of national debate. Now, how can an impartial, impartial means like a referee, literally, as in a soccer match. How can an impartial arbiter, such as the SABC, if there is that debate, there's Kaizer Chiefs, there's Orlando Pirates, how can they associate themselves with one of the two contending ideas and call it impartial? It's impossible. That's the quintessential. If your leadership here, your leadership, one of the duties your leadership has is to be impartial. But if your leadership says, no, Mr. Bofal, only listen to Mr. Mutao or vice versa, then the impartiality is not there. I mean, that's so basic that it really doesn't even need repetition. That if indeed, as they say, there is this crucial national debate, then the referee or the impartial referee or adjudicator cannot then side with the one or the other. And they must make it clear. So on all those three elements, accuracy, independence, impartiality, it fails. but dismally. Now, if that is so, my lady, our law is very simple on this. Even the slightest, the most prima facie violation of rights is unlawful. Unless, of course, there's, as lawyers always have, unless you can show a Section 36 justification.
Yes.
Of the.
Mr. Mpofu, I'm reminding you again.
Yes.
I have read,
Yeah.
and I do understand, and I'm giving you 5 minutes to wrap up.
My lady, well, okay, my lady, I don't want to debate that issue. But the point we simply want to make, my lady, is that as far as the Section 172 order is concerned, your ladyship does not have an option, quite frankly. To put, since we don't have time, we must just call a spade a spade.
Yes.
The Section 172(1)(a) says that the court must. So
Having found that it's unconstitutional, the court must.
Yes. So in this case, that means if you find that it's inaccurate, it's independent, or it's not impartial. In other words, it's a breach of the corresponding Section 16 rights to receive accurate information, to receive independent information, to receive impartial information. Then that's the end of the case, quite frankly, because here, fortunately, there's no Section 36 defense that has been raised. So as far as the declarator, what you do with the declarator is another matter. But as far as the declarator is concerned, there is no humanly possible reason why your ladyship can find that the violations have not happened prima facie and then without being met with the Section 36, which then graduates it from prima facie to actual. That's how the system works. So that's the declarator. It's not possible to escape it. As far as the review relief, my lady, is concerned, we want to say two things just to save time. One is that itself, it is an alternative remedy, and because the case for the declarator is so strong, it's likely that the court will never have to reach the review relief. But if the court does, for some reason, to reach that relief, then we point out that in any event, the issue about internal remedies is irrelevant because that only attaches to the PAJA part of the relief, whereas we also, rely on legality. So, in any event, my lady, there's nobody again. I'm sure my learned friend, not Mr. Mutao at least, who's going to argue that if the information is inaccurate, it's not independent, it's not impartial, and so on, then it's not biased in the PAJA sense of the word, or even in the common law sense of the word, because that's what this court said. Class in J, fair, unbiased, impartial, and independent. So on that basis, the alternative review relief really is a no-brainer with greatest respect to my learned friend who seems to think that there's something difficult about finding. So what do we then have, my lady, in terms of the summary? What we're saying is that unless really the court is saying, look, the rights can be violated, but there's no vindication. Remember, the only vindication of rights of people is the courts. They can't take up stones and go and throw them at the SABC or whatever. They have to come to a court of law, that we are a constitutional democracy, and say that our rights have been violated, otherwise they to resort to self-help. But the only help they have is yourself, my lady. For the court to intervene, to say you may not be the mouthpiece of a government, you may not be the purveyor of inaccurate information, and you may not be the conveyor of propaganda. I just want to end by giving your ladyship this what the Oxford Dictionary says So definitions from Oxford Languages of what propaganda is. It says information, especially of a biased or misleading nature, which is what we're dealing with now, used to promote a political cause or point of view, and that's what propaganda is. The dissemination of propaganda as a political strategy. And as we say, the people who started this thing are entitled. That's what they do. That's what they get paid for, to give propaganda and to tell us that they're going to give us houses and all sorts of things and not do it. That's fine. That's allowed. But what is not allowed is for an organ of state to be a conduit of propaganda, which is information, which is usually, as it says, biased or misleading in nature to promote a cause or an agenda, actually, to put it mildly, to promote a particular agenda. On that basis, my lady, the relief sought should be granted. We respectfully submit the main relief, if nothing else, and that your leadership or the courts, this court or the next one or whichever, ought to then intervene and in favor of citizens. And we say this case is probably as I say, higher than the TAC case, the fraud bomb case, and all those cases where the courts were asked to intervene, where the propaganda those days was not that there's a GNU, it was that HIV does not cause AIDS. So that if the court had to intervene to say, well, if you are doing this, so many people will die, and so on and so on, and therefore, and what we're saying is, to quote Mzoke Mbuli, the death of the brain is the same as the death of the body. Ukulimala kwengqondo, ukulimala komuntu, ukulimala kwesizwe, ukulimala komndeni.
Thank you, Mr. Mpofu.
Lady, just for purposes of proper housekeeping as well, your ladyship has a copy of the unsigned supplementary affidavit. I beg leave to hand up the signed one, and we've also prepared a bundle of statutes. My lady, let me perhaps just qualify that by indicating sorry. I note, my lady, that your ladyship said she has another matter.
Yes.
And I noted that my learned friend argued for an hour and 20 minutes.
So he did, well, an hour
Yes.
and a quarter.
1 hour 40, my lady.
No,
My lady,
I'm at 11:30.
Yeah,
Let's not exaggerate.
No, sorry, my lady. I thought it's. Oh, sorry. I thought your ladyship is saying 1 hour 40. No, I was saying 1 hour 20.
And I said an hour and a quarter.
Oh, an hour and a, oh, sorry, my lady. I didn't hear that second part. I apologize. The intention was not to exaggerate, but simply to inquire from your ladyship, given that your ladyship has another matter, if there is an indication, perhaps from a time perspective, that your ladyship wishes to indicate, because that will then impact on the presentation of the case.
Please be as brief as you can. I have read, you have heard Mr. Mpofu's argument. You know what is important in your argument. And yeah, if we have to run late, we have to run late, but I would prefer not to.
Thank you, my lady. My lady, we've raised the question of urgency, and I'm going to spend time on the topic with reference to providing, or perhaps by way of providing your ladyship with the references in the papers and in the heads for your ladyship's ease of navigation. My lady, your ladyship would have seen, and we would suggest that the appropriate starting point is for your ladyship to have regard to paragraph 15 of the founding affidavit.
Yeah. Okay.
Lady, that is where the applicant in dealing with urgency says, although the matter is inherently urgent, the nature and magnitude of the alleged constitutional violations, the matter will be set down on the basis of a request to the Honorable Deputy Justice, well, Deputy Judge President, I suppose, for a special allocation, hopefully by agreement between the parties. As such, the respondent has been granted a relatively long period of time within which to file the record and or answering affidavit. Any alleged urgency will therefore relate to the filing of the replying affidavit, heads of argument and or proposed set down date, all subject to alternative directives of the Honorable Deputy Judge President per either request or agreement. My lady, there's another reference. I'm not going to read it, my lady. It's paragraphs 85 to 89
Yes.
of the founding affidavit. And
it's also in the notice of motion, I believe.
yes, my lady, it's also. Our learned friend refers to the decision of Apleni. And one thing that your ladyship will notice from that decision is that that matter was referred to the Deputy Judge President for a special allocation to take care exactly of the exigencies, firstly, of the matter, but secondly, given the nature of the matter and the time that is required to ventilate the dispute. And my lady, that is best illustrated within the very circumstances that we find ourselves, that we are in the urgent court and we now need to confine our argument and decide which aspect do we leave out and which ones do we focus on. And your ladyship is aware also that there are a number of courts, including the decision of in re several matters, where the courts speak about the inappropriateness of dealing with complex matters. And even on the applicant's version, they say this application raises novel issues. And in paragraph 15 of that judgment, as your ladyship would know, that's one of the issues that His Lordship Justice Wepener deals with. And your ladyship will also know that he was not echoing a new principle. There are a number of decisions, of course, that espouse that principle. So, my lady, the question of urgency, as your ladyship would know, is determined with reference to the question whether a party would be able to obtain substantial relief in due course. And we say the very fact that the applicant catered for that possibility is illuminating of the fact that this relief is not one that they needed this week in this urgent court and on this urgent basis. And for that reason, the response in the replying affidavit that because the record was late and the answering affidavit was late, they are entitled to then proceed. Of course, my lady, it ignores two aspects. The first aspect is this. The record was filed, and subsequent thereto, the answering affidavit was filed. And when we came before your ladyship on Tuesday, the applicant made an election. Faced with a record that has been filed in an answering affidavit, whatever its misgivings, as echoed by the applicants. There was an option, even on the application of a plenary, to refer the matter to the Deputy Judge President for a special allocation. My lady, the applicants elected that they are going to file a replying affidavit. And they requested that your ladyship should stand the matter down and afford them an opportunity to file a reply on Wednesday noon, and that the parties should file their heads at 6 o'clock. Now, what consequences flow from that? It is this, that the complaint about either the irregularity or the shortcomings of the record are not live issues before your ladyship, because your ladyship would know that if there is any irregularity by way of a step that has been taken by a party, the party that complains of that irregular step ought to issue a Rule 30. There's no Rule 30, my lady. And with the reply having been filed, and in circumstances where the applicant says even the supplementary affidavit, there's no objection to it, what that means is then your ladyship has the totality of the pleadings before her, and would submit then that based on the applicant's election, your ladyship would have to determine the matter within the four corners of the complete pleadings. I'm not going to use terms such as schizophrenia. Lady, they're important issues to be determined. And your ladyship applying the law with reference to the authorities that we've cited in our heads of argument, including the nature of the relief that is being sought, where courts have expressed themselves that reviews are not matters that are justified in jumping the queue. And your ladyship would have to determine the question whether has the applicant shown that this is a case of such a nature against its own allegations in the founding affidavit and in the notice of motion that could not wait, and or be dealt with by way of a process where we would have been allocated a judge who would have time to vindicate the entirety of the issues. And my lady, therein the issues that the courts raise regarding inappropriateness of setting such matters down in the urgent court raise their heads. My lady, we filed heads, and we, understanding that your ladyship sitting in the urgent court does not have time to go and find the law reports, we have adopted an approach where the paragraphs that are being relied upon have been reproduced for your ladyship so that your ladyship can find them with ease for purposes of deciding the point one way or the other. And
I noticed that unfortunately I tend to go and find it anyway because of context. But thank you.
Thank you, my lady. Then, my lady, we, for the reasons that we've set out in the heads, the question of urgency, we submit should be decided against the applicant. And in particular, if I can just ask your ladyship to have regard to paragraph 16 of the founding affidavit, where the applicant states that the application raises novel and multiple issues of constitutional importance.
Yeah.
My lady, if I can then deal with the merits, and insofar as the merits are concerned, we intend to address the following topics, my lady. Firstly, we intend to address the statutory scheme, i.e. the regulatory framework. And second, we intend to deal with the constitutional challenge for a declaration of constitutional invalidity. Third, we intend to deal with the alternative relief in the form of a review. Fourth, we will deal with costs and the concluding remarks.
So the question of the 16A notice you are dealing with
Sorry, Marie, I apologize, my lady. Thank you. In in a rush to try and deal with the issues within a reasonable time period, my lady, I omitted to deal with that issue. There is, of course, the question of the Rule 16A, which we have raised, my lady, the non-compliance of which we submit. The courts have spoken. Score versus Yoste and a trail of authorities that speaks to the incompetence of an application that seeks a declaration of constitutional invalidity, but does so without having complied with Rule 16A. So, my lady, that also...
and did you raise that point in your affidavit? I can't remember.
No, my lady, it's not in the affidavit.
It's not in there.
We've raised it in our heads, and your ladyship will find that in paragraphs 38 to 42 of our heads.
That's what I thought.
Yes. And in any event, my lady, as a point of law,
It's a legal point.
it's a legal point. So, my lady, for that reason too, we submit that those 2 points are dispositive of the application. And in fact, in the order of priority, your ladyship could even start with the 16A first, and dispose of the entirety of the application on that basis. Then, if your ladyship does not, or is not inclined to adopt that approach, then the question of urgency provides an equally, though slightly different relief, because the lack of urgency would be visited with the strike off. My lady, your ladyship would know, in terms of the regulatory framework, if I may just quickly deal with that issue. The starting point is Section 192 of the Constitution, in terms of which national legislation must be established, or in terms of which national legislation ought to be put in place to establish an independent authority to ensure fairness and a diversity of views broadly representing South African society, and we know that that regulatory body is ICASA. Then, my lady, there are at least 2 pieces of legislation that are referenced in the papers, and we've included copies thereof in the bundle of legislation, or in the legislation bundle. It's the ICASA Act and the Broadcasting Act. And, my lady, the importance of these 2 legislations and the provisions to which I'm going to deal with next is the following: that your ladyship would recall the principle, the overarching principle, when you deal with a matter that has as one of the features a declaration of constitutional invalidity. What often arises as a principle is this: that if a party does not seek to impugn the instrument pursuant to which the power is being exercised, that challenge is a misguided challenge. And
he walked in and he walked out. Please
Lady,
can someone
moving.
tell that person to silence their phone when they come back in? And everybody else, make sure your phone is silent. This is I don't understand why it's not an automatic thing. Sorry, Mr. Motau, please carry on.
Thank you, my lady. My lady, I was dealing with the well-known principle that if a party does not impugn the validity and or lawfulness of the instrument pursuant to which the power is being exercised, then the attack, fanciful as it might be and perhaps attractive as it might be, is a misguided attempt.
But Mr. Motau, is there any real dispute that the SABC is required to be a platform that allows the dissemination of views in a balanced manner, impartial, that does not become a mouthpiece for propaganda? What was it? Independent.
Well, the three.
Accurate.
Yes, the 3 is accurate, impartial.
Most
Normally,
important, accurate.
No, there isn't.
There's no dispute, so we don't have to go there. isn't the real question whether it is actually falling foul of those requirements?
Yes, my lady. Perhaps, my lady, there's a quicker way to do so. My lady, in paragraph, in responding to paragraph 37 of the founding affidavit, if I can just go directly there in the answering affidavit. Page 02-26, it's the answering affidavit commencing from paragraph 71.
26.
This numbering is very odd. Paragraph
71. My lady, leading into that paragraph and the paragraphs that follow thereafter, we would submit there are the following questions that one has to pose. In the context of the statutory framework that requires of the SABC to represent and or to present views on a balanced basis, and those views would include political views, religious views, etc., which is uncontroversial. The question is the following. In the South African scenario, does the current government refer to itself as the government of national unity? And the answer to that, lady, is, of course it does. The second question that one would ask is there any controversy, i.e., is there any political discourse in the political arena in terms of which parties have expressed different views as to whether the government's usage of the term is correct or not? And the answer to that has to be yes. And by way of an example, the reference to a program is referred to commencing from paragraph 71, and this is the program that has been referred to in the founding affidavit. And the deponent says, in the said program, Professor Mervyn Gumede and Mr. Tito Mboweni did not agree that the current government is or is not a GNU. Mr. Mboweni said that this current government is not a GNU. He compared the 1994 and the current GNU and concluded that the former was negotiated during a transitional period and the political parties agreed to the formation of a GNU. Professor Gumede, on the other hand, insisted that the current government is aptly referred to as a GNU, as it seeks to promote national unity and to address a national crisis created by high levels of youth unemployment, poverty, decaying public infrastructure, poor quality of education, decay of social fiber, especially on the youth, and high levels of violent crimes such as murder and rape, etc. He then concluded that there is a national crisis and the GNU is the appropriate response to deal with. Now, let me pause there. It is quite clear that this term is a politically contested term. And what does the SABC do in the context of that politically contested view? It creates, or it makes its platform available to inform its viewers and members of the public that there is a debate and there is no harmonious view regarding whether the government is in fact a GNU or not. And my lady, to do so with respect accords with the legislative imperatives that the SABC is enjoined to comply with, i.e. to present a plurality of views which are being contested without it itself associating and endorsing either one or the other. And it is for that reason that the question that is raised, even in our heads of argument, read in the together with the answering affidavit, it is this: does the SABC represent to be an arbiter apologize, an arbiter on the question, i.e., does the SABC endorse and or represent to the viewers that the usage of the term GNU is correct?
Yes.
Well, there's no such a thing. And in fact, that is not the applicant's case, because if that had been the case, we would be facing a different case. All that the SABC does is to report objectively that the government calls itself the government of national unity, but in that context, there is a debate. If one was dealing with a suppression of a view by the SABC, i.e., if the SABC was only promoting a view that says this is a government of national unity but does not present the opposing view, then, my lady, perhaps the three issues, to use our learned friend's categorization, would be implicated. So, my lady, those are not. Just simply on that one example and on that analogy alone, the application on its merits is completely defective. My lady, if I can then and Marit, might I just, for purposes of notation, just ask perhaps your ladyship to note the following sections, and I'm not going to read them because we submit these are going to be helpful for your ladyship in locating where the duties are in the Broadcasting Act. My lady, it's section 2D and section 2L, then section 3(1)A, section 3(5)B, D and F, section 6(1), section 6(3), and section 6(5)A. Then, my lady, it's section 8A, or section 6(8)A, B, D, E, and F, and section 10F, section 10(1)D. Then, my lady, with regard to the SABC editorial policy, we ask your ladyship to have regard to the following. It's clause 2.2 at page 02-105. Clause 2.232, which deals with editorial independence, it's at page 02-106 and P02-125, clauses 5.1 to 5.3. Then, my lady, 02-157, which is a complaints management process, and we submit that those should be read together with the answering affidavit, the paragraphs 48 to 55. And the import of the submission is this, my lady. If one tests the question of accuracy, is it inaccurate for the SABC to report that the government is referring to itself as the government of national unity, without endorsing the correctness thereof, and to go a step further and say this is a contested issue? The applicants refer to an interview that Ms. Zille gave, and your ladyship saw in the supplementary affidavit there are two other interviews that Ms. Zille gave where she says the opposite. She says we are in a government of national unity and etc., etc. And the question is... She
says it's a coalition government.
Yes, my lady, yes.
We are not in a government.
Well, in the latest statement...
Oh, you mean the other...
Yes, in the other one.
You referred to...
Yes.
Oh, sorry.
Twice she says we are in a government of national unity. But, my lady, the point is the following. Politicians, for whatever reason, My lady, on a day that they are happy with one another, they say we are in a government of national unity, and something happens on the next day and somebody goes and pronounces that we are not. It is an irrelevant consideration for purposes of compliance with the legislative injunctions. The only requirement would be that even where there is a contradiction by a member of a political party, the SABC's duty in complying with the accuracy injunction would have to report the fact that on this day, Ms. Zille said we are in a government of national unity. On this day, she said we are not. And 3 weeks down the line, she said we are. My lady, that is, with respect, what is required for purposes of meeting the threshold of reporting fairly, reporting in a balanced way, reporting accurately. Without, my lady, the SABC representing that it adopts, for purposes of determining correctness of the usage of the term, one term or the other. Because, my lady, we submit there is no such statutory requirement. The Constitution imposes no such obligation on the SABC. And for that reason, my lady, the question of a declarator, the requirements of which we've set out in our heads of argument, and if I could just give your ladyship the reference, it's in the heads, paragraphs 52 to 63, paragraphs 11 to 16, and paragraph 6 to 10, where the question that one has to ask relative to the declaration, it is whether is there a right that these applicants enjoy before your ladyship which are being violated and or breached, requiring that your ladyship should intervene by granting either of the orders, either the maid or the alternative. And if on the construction that we've presented to your ladyship, that there is in fact no right that has been breached at all, my lady, that would be the end of the matter. The contested political terrain, yes, my lady, the politicians should do what they deem appropriate to deal with it. But absent a statutory injunction that says, in the context of a disputed political term, the statute imposes an obligation on the part of a public broadcaster to be an arbiter of the usage of that term. My lady, absent that, we submit. That is the end of it, of at least this application. Whether they're going to take government to court on whether it is correct to use that term, and whether Ms. Zille's characterization of what President Ramaphosa did or did not do and what kind of a leaf he put up or he didn't, President Ramaphosa will answer for himself in that dispute. If the DA takes the ANC to court, or whoever that takes the government to court to challenge the correct usage of that term. And that's the reason why your ladyship does not even need, for purposes of making this determination, to say whether Mr. Ramaphosa did in fact say this or he didn't say that. It's of no consequence. Because what this suggests, my lady, is this. If Ms. Zille, 4 months down the line, comes back and say we are in fact in a government of national unity, does that implicate the duties that the SABC has beyond simply to report that fact, my lady, but on the applicant's higher duties, as they say? They suggest, contrary to statute, that the SABC is supposed to do more. But what is this more, lady? And as your ladyship asked, how does this poison the minds of ordinary South Africans who have access to a platform that shows that there is a school of thought that says this is a GNU, and there's a different school of thought that says it isn't. My lady, if I can then deal with the alternative remedy by way of a review. The applicants accept that the review relief is severable from the declaratory. And they say this in paragraph 83 of the founding affidavit. And my lady, we say that is important because if there is no constitutional declaration relief that is competent, then PAJA imposes certain obligations, including the duty to exhaust internal remedies. And the need to apply to your ladyship in terms of section 7.2 that they be exempted from complying with that duty to exhaust internal remedies. Decisions are well known, my lady. We've referred to Denge Tenge. Your ladyship is familiar with Koyabe. And in this court, the Deputy Judge President dealt with Swanvest versus the Minister of Agriculture, espousing the same principle that absent an application for the exemption of internal remedies, your ladyship's hands are tied. And one cannot, under the rubric that, well, for purposes of convenience, the internal remedies are not, or will not, or need not be exhausted because we are dealing with one dispute. That would have been an answer for a constitutional declaration where a proper case had been found or had been made out, because that falls outside of the competence of internal processes. But when you're dealing with PAJA, lady, we make 2 points. One, we've made the point that the definition is not satisfied. Your ladyship is aware of the decision of Motau in the Constitutional Court that deals with or grapples with that distinction between legality and a PAJA review. So we submit the definition firstly is not satisfied. But secondly, even if they were properly before your ladyship, the duty to apply for an exemption from complying with the internal remedies is one that PAJA imposes on a peremptory basis that it ought to be so.
Even if the definition is not satisfied, then that doesn't preclude them from relying on legality review.
Yes, which takes me to the next point. Then the legality review, your ladyship would say, well, what are the legislative injunctions? What duties or statutory duties does the SABC have for purposes of having, in dealing with complying or in treating the GNU topic? And your ladyship will say, does the editorial policy preclude the SABC to report the way it did? One. Secondly, your ladyship will say, adjudged also against the parameters of the Broadcasting Act. Is this a misrepresentation? Or is this an infringement, rather, in breach of the legal duties and obligations? And my lady, once that is unavailable, because there is no showing that which of the particular statutes is being infringed. And my lady, we've raised the question of the invocation of the Constitution in the abstract without subjecting it to the facts. But if your ladyship, assuming your ladyship takes a benevolent interpretation that it is permissible to do so, when one gets to the PAJA review, we've made the point that all that has happened is that there has been a citation or a recital of the PAJA ground without engaging the facts to show how each of them fits within those. So my lady, at the end, or in the final analysis, once there is compliance with statutory duties and the regulatory framework, it provides a full answer, because your ladyship then, in terms of the principle of even constitutional avoidance, there's no need to get there.
Subsidiarity.
Subsidiarity comes in, my lady, and it also answers the question of legality, and thus your leadership does not need to get into that debate whether can one use Pacha grounds and dress them up differently as a legality review, because that's
Pacha grounds were taken from the common law.
The subsuming of those grounds, as it were, subsuming of the common law grounds into Pacha, as your leadership will recall.
So that doesn't mean they have been removed from legality review. They're still there.
Yes, but my lady, I was making a slightly different point.
Okay.
There is this debate in our courts, and there are various articles on whether can one properly take grounds that properly belong in Pacha and dress them up as legality. I'm saying that debate does not even arise for your ladyship's consideration.
Okay.
And that's why I was saying we don't get that far, because here you have the identified and an acceptance that there is an editorial policy, there is an element of independence from the SABC, and that if the SABC says government calls itself this, doesn't infringe independence, if a year down the line this government calls itself the seventh administration, whatever they may choose that they want to call itself, that would still be, it would still accord with the principle of accuracy, principle of independence, and impartiality. So I was looking at that. My lady, unless there is anything else, we wish to address the question of costs. And when we deal with the question of costs, my lady, we refer to the fact that the courts recognize that the exceptions to BioWatch do not protect a party from being insulated against a cost order.
Do the courts not also recognize that a party who chooses to file things overnight with no explanation whatsoever might well bear the financial disadvantage of the court's displeasure?
My lady, we let me answer that on two bases. The one is, one of two things could have happened, and which is where I started, my lady. I said, well, if we had come here on Tuesday and they said, well, this affidavit is late, we don't accept it, then you must apply for condonation, then my lady, that would have happened. But
I could have said that.
Including,
it's
yes.
not about them. As I said to Mr. Mpofu, it's not only about what you say, it's also about what I say.
Yes,
it's about how you are treating the court.
Yes, Mali, that was going to be the next point that I address. It's similar to the question of agents, even if we were not here, as your ladyship said.
Yes.
So I'm quite cognizant of that fact, and I was going to address that next point. Then it would have triggered the duty to explain the default and what caused it, etc., etc.
Does the duty to explain not exist already?
My lady, in the agent court, and I'm not saying there is a license to disregard courtesy to the court. I should not be here
You've had this thing since the 12th of July. I got it last Thursday.
My lady, unfortunately, the point that I was trying to make is if there had been any objection, and let me deal with it again, but on two bases. If there had been,
keep quiet.
So if there had been an objection, or at least we'd been alerted, whether by way of a Rule 30 or an intimation that there is a misgiving regarding the late filing of the answering affidavit, that would have been reacted to. With regard to the court's concern that the court is raising, it leads to the question of the court's discretion in respect of costs. And your ladyship is entitled, even despite the authorities that we cite, one of which is that ultimately it is the exercise of your ladyship discretion. Your ladyship could dismiss the application for non-compliance with Rule 16A. Your ladyship could strike it for lack of urgency, or your ladyship could dismiss it on the merits and order that there should be no order as to costs. My lady, we would submit that in the alternative. My lady, unless there's anything else, we don't depart from the submissions that we've made in our heads, and we ask your ladyship to consider them.
I shall do so very carefully. Thank you, Mr. Mutau.
Thank you, my lady. Sorry, my lady.
Wait,
Might I just take? Sorry. Thanks, my lady. Helpfully, I'm being reminded what FXI was about. If I can just give your ladyship the following 3 paragraphs. It's paragraph 90, paragraph 98, and paragraph 99 of FXI. Your ladyship will recall in FXI, the issue was the violation of the editorial policy, and there was also the issue of the violation of Section 10 of the Broadcasting Act. And your ladyship, Justice Klassen, found no constitutional violations in that case, even though FXI prevailed. Your ladyship will know the authority. Lady, unless there's anything else, those are submissions.
Thank you. Mr. Mpofu, the court staff also need a bit of a break before we resume, so I'm going to ask you to be as short as you possibly can. I'm not going to cut you off, but please, just as short as you can.
I don't know what your ladyship is asking for, a break or?
No.
Oh, okay.
I'm saying before we resume for the next matter,
yes.
the court staff needs a break.
Okay,
so
yes. No, and we're indebted to your ladyship and the staff for
yes.
for not taking even the tea break. No, my lady, there's not much really to say because the case has not been met. Let me just start quickly with the last points that Mr. Tau said. Just on a lighter note, my lady, when he talks about FXI, the FXI case, you'll see at paragraph 6, my lady, that it says there that this was about the complaint about the so-called blacklisting. And it says, however, the Chief Executive Officer of SABC, Advocate Mpofu, had simultaneously appointed a commission of inquiry to investigate these events. Now that makes 2 points. One is that the mere allegation that there was such a thing was enough to provoke that Advocate Mpofu to say there needs to be an inquiry into this because the public is being allegedly poisoned. But the other point is that I know very well about the FXI case. And the FXI case, my lady, has got nothing to do with the issues that Mr. Mutau is raising. Let me, if your ladyship stops me, then at least let me do so once when I've said this. There is no defense that has been presented to you, my lady, on the case that you have presented. Mr. Mutau no wonder he's leaving the room, my lady. I would if I was him at this point. But fortunately, he's got able genius. Mr. Mutau has answered a completely different point, a case. The case that Mr. Mutau is talking about talks about other, not what we have pleaded. It's about diversity, which is also an SABC standard, and balance, which is also an SABC standard. But that's not what we have pleaded here. If we were saying the SABC standing there at the door, and if you come in, they say, do you support the GNU or don't you? And if you don't, they turn you away. Then that's an issue about diversity. It means they're not allowing the plurality of views. That's not this case before you. This case has got nothing to do with plurality of views. We commend and we praise the SABC for that. Well done. This case is not about balanced views. We commend and praise them for that. Well done. This case is about the things that Mr. Mutau did not address, not the issues that he says are here. So, with the greatest respect, Mr. Mutau has said nothing about the case that we have pleaded that he was here to meet, but he's telling us about other nice stories, good luck stories of good hunting. Now, back to the case before you, because since it has not been addressed. It is not our case, my lady, that actually Mr. Mutau, I should employ him as a member of my team, because he makes the case even better than us. He says, does the SABC endorse one of the views? And he says, if the answer to that question is yes, then they must lose. Well, then they must lose, because that's exactly what we are saying that they do. We're not saying that they don't allow other people to present the case. We're saying that as a referee, as an arbiter, they have sided with one of the two boxers or soccer players or whatever the referee is supposed to be refereeing. That's the issue. It's exactly as coined by Mr. Mutau. He's very correct. So it's not it's not a question of whether Ms. Zille on Monday says they are in a GNU and then on Wednesday says they are not. The point is that the SABC cannot say, okay, we align ourselves with the Monday Zille, the one who says, but we don't align ourselves with the Wednesday Zille. That's the point. He's missing the point completely. And that's why we said we agree that there is a debate. But that's the whole point about the debate. It's like moot court. So in the debate or the moot court, the judge or the arbiter cannot align themselves with one of the pugilists. Really, it's supposed to be a simple point. The second point is that they, one of the things, although he advisedly did not raise it now, but it's in their papers, is that, no, this is a political term. But there's nothing further from the truth, my lady. I'm sorry, my lady, if I may just try and find my constitution. Even in this one, my lady, from Mr. Mutau.
I should make a disclosure. It was actually donated by someone who's presiding.
As the well, even better. Even better, even in the one that comes from Mr. Mutau and from even higher places. My lady, if you go to Schedule 6, Annexure B of the Constitution, Mr. Mutau's Constitution,
Transitional possibility.
the heading is Government of National Unity, National Sphere. And then it goes to Annexure C, Government of National Unity, Provincial. Now, and he said, no, it's not a legal term. Well, it's a constitutional term, at least. Let's agree on that, because it's here in the Constitution. So Mr. Mutau's point, or let me put it this way, about it being a political term. Remember, my lady, genocide. Is that a political term or a legal term? The answer is that it's both. So the court in The Hague didn't care about the political rhetoric of people jumping up and down, shouting genocide and so on. The court simply confined itself with the legal definition of genocide and coldly looked at the facts and decide whether they fit that legal definition or not. It's that simple. So the mere fact that the term is also used by politicians is neither here nor there. Lawyers are supposed scientifically and forensically, at least, maybe if not scientifically, to look into that term, genocide, and test as to whether it fits or does not fit the legal definition. That's it. So don't scare us with, oh, it's a political term. So what? Black is a political term. White is a political term, but it's also a legal term defined in the BEE Act and other statutes. So let's put that to bed. The third point is that Mr. Mutau? No, I'm sorry. To call it a third point because it's related to the first, MK4. MK4 is on 02-847 on one of the versions.
It's in Annexure 2?
It's annexed to the FA, to the finding of David Maledi. Thank you. That's a better way to find it.
Maybe Mr. Muwela can do his thing.
No, it's fine. Has the leadership found it?
I am getting there. Oh, I see what's happened. Annexure?
MK4. It's actually MK4 and 5. They're both.
Right, I'm there.
You've got. Apparently, the internet is broken. Sorry, Malaysia. Can you just wait? I'll use one because we don't have time. Here's an article by Bulelani Philip. Document. And it says ministers to align with government of national unity. And then it says, I'll just choose a random paragraph. In the 7th administration of government of national unity, no cabinet minister will go it alone, and so on and so on. And then here's the part where she's not quoting now. She says the Forum of Directors of General is currently doing a policy review of all GNU political partners. And then in another paragraph, now that we are in the GNU, we all collectively agree, and the UDM, and so on and so on. And then...
this is quoting what she says. This is all a summary of what
no,
she
my lady,
said.
but I've just distinguished between where he's quoting and when he's not quoting, where he makes the suggestions himself. And 5.
MK5, yeah?
Currently, the DA is part of the government of national unity, with President Ramaphosa appointing its leader, John Steenhuisen, the new Minister of Agriculture.
Yes.
No one is being quoted there.
Yes.
Right? Then the next one, next part, towards the end, the DA's decision to shun the government of provincial unity, whatever that is, comes as the party feels the options presented were unreasonable, not quoting anyone, and so on. So the point is that Mr. Mutau's own question is answered in MK4 and MK5 by the SABC itself, not saying so-and-so says there's a GPU or a GNU. Now here's the thing, my lady, going back to just simple forensics. We say in your affidavit, my lady, I'm sorry, in our finding affidavit, my lady, we say in Gauteng, there's a government, a minority government, where only the minority parties are participating. The SABC calls it a government of provincial unity. In KZN, there's a government that excludes the largest party. The SABC calls it a government of provincial unity. In Northern Cape, there's a government where the ANC is in bed with the Orania party, the FF+. They call it a government of provincial unity. So all these three things can't, how can those three different, completely different things be the same thing? They are only the same thing because the ANC says so, or the government says so. But logically, even if you take a 5-year-old child and say, can this thing is pink, this one is orange, this one is green, can they all be black? You know, it's so that's the absurdity of saying that they are quoting. Who are they quoting when they say the clear minority government in Gauteng is a government of provincial? Okay. Now, here's the point, my lady. Mr. Mutau is missing the point about statutes. Section 172, my lady, does not say what Mr. Mutau says it says. So he says, for you to get legality, you must check whether you have broken any statute. I'll give him this. If I was marking his script, I would give him half a mark. Because there is that legality of breaching a statute or common law and so on and so on. But that's not the legality that is envisaged in Section 172. Section 172, my lady, talks about, where's Mr. Mutau's book? Talks about the breach of the Constitution, right? None of the things that Mr. Mutau is telling us about. It says, when deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution, not with the statute or the common law. And that's what we are saying here, that the conduct is inconsistent with the Constitution. And Mr. Mutau's subsidiarity point is a non-point. Subsidiarity in this case only deals with Section 33 of the Constitution. Of course, you cannot enforce Section 33 of the Constitution directly. Why? Because there's a statute called PAJA. That's the subsidiarity point. But when you are enforcing dignity, where's the statute? There's no something called the Dignity Act. When you are enforcing freedom of expression, where's the statute? There's no such thing called the Freedom of Expression Act. So when you are enforcing those provisions of the Constitution, subsidiarity does not apply. There are certain sections of the Constitution, such as Section 23, the labor section, Section 33, and so on, where there are subsidiary legislations that have been put. So subsidiarity has got absolutely, but absolutely nothing to do with what we are busy with here today. So then then Mr. Mutau again helps us. He says, well, now talking about legality with a small letter L. He says, where do we say that they have breached the statutes and the policies? The answer is everywhere, because the statutes and the policies also provide for accuracy, independence, and impartiality. So even that small letter legality has been satisfied, in the sense that those statutes, unless, you know, they say when you point a finger, there are so many fingers pointing at you. What Mr. Mutau cannot do is, without attacking the constitutionality of the ECA and the Broadcasting Act and the policies, he cannot then say that those things must not be satisfied. And that's why I made this artificial exercise of saying you can import those words from those instruments right into the Constitution. So when the Constitution says you have a duty or rather the citizens have a duty to receive information from the SABC, what it means in the context of the SABC is that they have a right to receive accurate, independent, and impartial information, until you attack the constitutionality of those statutes that qualify that right in the Constitution. That's what happens. So my lady, the point is this: that the right of the people, I don't know how to put this, the right not to be lied to is a right to your own dignity, if you like. In other words, nobody must just wake up one day and want to tell you an untruth. That is so. These things are just words, dignity, but you need to unpack them and conceptualize them as they relate to real, normal people minding their own business. As to whether do they have a right to receive accurate information or not. If you say no, fine, then we'll go home. Then we must lose the case.
I think you must go home anyway,
Yeah.
but that doesn't mean
Yes. Well, we'll be very happy to go home with a victory, Malay. But but if you say no, those rights do not translate into Section 10 rights or Section 9 rights or 16 rights or 19 rights in the case of Mr. Zuma, the first applicant. Remember, he says, I'm here as a citizen.
yes.
And then the MK party says we're here as a political party. Now the political party, again, my lady, this is no trivial factor. When MK says in its document, we received 2.6 million votes, it looks like it's just a number. Those are 2.6 million human beings
Yes.
that are saying to this court, protect us from being abused. 2.6, not one person sitting in some hospital. Human beings, like you and me, and mostly this one sitting here wearing green shirts. So my lady, it's a matter that touches on the lives and the rights at the heart of this democracy. It might not look like it. It's probably the most important case in the so-called 7th administration in the era that we're in, because it seeks to say whether or not are we now in to be lied to for the next 5 years, willy-nilly with the courts watching and folding their arms, or when that happens, are we going to be protected? It's fine. If this so-called GNU is here to introduce that, well, the people might be illiterate, but they're not stupid. They are certainly not stupid. And they know when they are being lied to. And if either the court will protect them or they'll protect themselves. But they're not going to sit idly for 5 years and enjoy this holiday of intellectual application induced by an instrument that they pay licenses for. Every year they have to pay money to be lied to. No. So as I say, my lady, it's
Mr. Mpofu,
and I'm confining.
I
sorry.
must just warn you
Yes.
that it's not appropriate to say either the court will protect them or they will protect themselves. That sounds a little bit like a threat,
Yes.
and I don't take kindly to that.
No, my lady. You see, my lady, that the last time that happened to me, 400 people died. I said this to a court in 2021, I think. Was it 21? Yes. KZN. So I wasn't even sure where. And one of my colleagues stood up and said, because I said the people know when the law is being applied in a particular way. One of my colleagues stood up and said, that sounds like a threat to let SABC. I sat down. And 2 weeks later, 400
I'm not asking you to sit
died.
down.
Yeah, no.
I'm saying don't threaten this court to find a certain way.
No, I'm not. I have every right, my lady, not to threaten, but to implore the court to apply the law. And
The
I will
court
do
will
so
apply the
fearlessly. Yes.
Also fearlessly.
Yes, that I will do so fearlessly. When I say if the court, it's not me, my lady, it's the Constitution. It says the court must.
Yes.
Right? That's not a threat. It's an order from the people.
And the court must do so fearlessly also.
Yes. So that order comes from the people, not from both. The order that says must. The Constitution says we, the people, not we, the courts, or we, the SABC. We, the people. And if the people say the court must declare their violation of their rights to be invalid, then that's what they say. I may not say it myself, but it's not going to change the Constitution. So please, my lady, that's not what the intention is. The intention is to say that by the way, that's the reason, and I don't know your ladyship how she's going to take it. The reason we have a constitution is exactly to avoid that. The reason we have laws is so that everyone must play according to the laws. Everyone, including the court. Yes, including the court. So because the people decided in their wisdom to codify their values into a constitution so that they don't have to, if my learned friend Mr. Muela steals my car, I don't go and steal his car. I must go to the police station. That's what the people decided, not me. So I'm afraid I have to say this maybe differently. If and by the way, it's true, my lady. That's why we have a right of appeal, for example. So if this court does not protect the interests of the applicants, then they're going to protect themselves in the SCA.
Yes.
And then they're going to protect themselves in the Constitutional Court.
And that's what it's there for.
Yes. So why is it a threat to say you're going to do that? It's a threat of a right of what you are entitled to. That's exactly what they're going to do. I won't speak.
That's what you mean?
Yes. Yeah. Let me not speak for the people now. Let me speak for MK and Mr. Zuma. If they are not protected, they're going to take the matter further. Thank you. All right. So the last point, my lady, which is Mr. Mutau, when Mr. Mutau started. Mr. Mutau is, I don't know what to call him. He says he's dealing with agency, but the only section in the founding affidavit that he doesn't deal with is the section that deals with agency. He deals with something about the DJP, which is put in the introduction, and he misreads that. Because when you say, we always do this, I've done it in this court, and I'll give you an example. When you say, I'm going to go to the agent court, or I'm going to approach the DJP to make a special allocation, you are not, by so doing, relinquishing your agency. He's told us exactly that's what happened in Apleni. In Apleni, the matter was urgent. Otherwise, Judge Fabricius would not have spoken about it if there was no agency issue. So there had a special allocation, but agency was still an issue. It has happened to this court to me several times. All we are saying, my lady, is that this court, and your ladyship knows it live right now, this court is busy, and it has a roll of 40, 50 matters, and so on. So it happens that you can say to the DJP, allocate us a judge who's going to look into this matter in the same week. It doesn't have to be 100 years later. In the same week, but allocate it to a particular judge. So it's got nothing to do with the agency. That's exactly what has happened in a matter that I'm involved in Cape Town. It was set down for the 3rd, and the DJP there gave us 3 judges on the 4th, which is the following day. This court, last year, when there was an urgent application brought by Mr. Zuma, or rather brought against him, now, then things change. When it was brought against him, then the court said, without anyone asking it, we are going to allocate this matter to a full court in the same week, and the DJP presided over that himself, without anyone asking for. We didn't ask, Mr. Ramaphosa didn't ask for it. But the world had to come to an end, and we had to be given because one person could not stand in the dock. But when it's 60 million people, no, it's fine. It's you know. So Mr. Mutau is not allowed to carefully avoid the sections. That's why he didn't address what is under the section on agency, which is that this is a continuing wrong and an egregious one over so many people, because he's reading the wrong section and avoiding the section which has a big heading called urgency. Yeah, it's page 02-173. F, capital letter F, urgency. And then it says, most of, in the present situation, violations are multiple and countless, and so on. Your ladyship knows. It does not address any of those. Sorry. Oh, yes. The so-called, the Rule 16A
Thanks.
Afterthought. You see, there's something called body language. When the party just wants to grab every technicality around the world, then you must know then they don't have a case. So the ladyship asked a pointed question. Did you raise this issue in your affidavit? No. Mr. Mutau was lecturing us about waiver and acceptance. So he says, if we said that there must be a replying affidavit, then we're waiving our right to complain. But it doesn't apply to them. So their failure to raise the 16A point in the papers so that audi alteram partem, we can deal with it in our reply, is not important. Well, that's not how the law should work. But in any event, Rule 16A or rather, non-compliance with Rule 16A is a technicality that is condonable. And here's what your sister Justice Kitley had to say about it. In the case of MSM versus MEC for Health, 2020-2, SA 567. At paragraph 13, she said, Rule 16A9 permits a court to condone non-compliance with a rule where this is in the interest of justice. In my view, a court should not likely condone the failure to comply with it. However, in this case, it seems to me that such condonation is justified. The plaintiff, like here, did not object to the amendment of the MEC's plea and so on and so on. Nor did the plaintiff raise non-compliance with Rule 16A, just like this respondent, at the start of the trial or even while the trial was running. By the time the issue was raised, all the evidence had been heard, as here, all the evidence has been exchanged, all the papers. It's because it was only raised yesterday. At least I saw it for the first time yesterday evening, midnight special. By the time the issue was raised, all the evidence had been heard, and all that remained was for argument to be presented, which was the situation last night. It was impossible for the MEC to comply with Rule 16A at that stage, which was the situation last night. To try to turn back the clock would have caused a lengthy postponement of proceedings with the possibility of needing to recall witnesses who had already testified. Same situation last night. The plaintiff did not seek such measures to be put in place, but relied instead on a technical objection, as here, to the fact that there was no compliance with the rule. In my view, it would not be in the interest of justice to uphold this technical objection and non-suit the MEC, and so on. And it is, in any event, in the interest of justice to condone the non-compliance with Rule 16A, and I hereby do. So, firstly, it's not raised, but even to the extent that it is raised, my lady, as a technicality, it is raised in such a way that a few hours before we come to court, we have no time to do anything about it. But here's the one, my lady, the killer. Mr. Mutau abuses this court for the last time, hopefully last night, by bringing a supplementary affidavit. In that supplementary affidavit, which came last night, he doesn't raise the 16A point. He raises Helen Zille and all sorts of things. When he now has another chance, the last chance which he has created himself illegally. But at least there's that chance to say, okay, by the way, there's also now this objection. No, it only surfaces in the heads of argument. And even subsequent to those heads of argument, it's not raised in the affidavit. Please, the courts really should not be abused to that extent. In any event, my lady, your ladyship is entitled to take judicial notice of the fact that this matter has been, everyone knows that the matter is happening. It has been, your ladyship has kindly permitted the public to have access to it as well. But that's because it's literally a technical point. There's no prejudice that the SABC can say it suffered by the non-compliance with Rule 16A in the urgent court in any event. Remember, Rule 16A says you must give 20 days and so on. Where's that 20 days in the context? From last night to now, there's no 20 days, there's not even 1 day. Sorry, my lady.
Mr. Mpofu, it's now 2:05.
Literally, I didn't do 2 minutes, man. 1 even. I'm just looking through my notes here. Yes. Just this last point, my lady. Mr. Mutau at least seems to agree grudgingly about the aspect of the definition of the GNU that relates to a national crisis. And even Dr. was that one of the Moonshot Pact, Dr. Gumede, who in that so-called debate, where we've given you the video, says that that element must be there of a national crisis, except that he then creates a fake crisis. There's no national crisis, my lady. A political party called the ANC lost elections. That's not a national crisis. It's a crisis for the ANC. So how can that be a national crisis if the Labour Party wins elections in Britain and next time another party loses and so on? How? So that's why we say Mr. Ramaphosa was quite entitled to look at it subjectively from his point of view as a crisis. It was a crisis for his party. But to then transport that subjective crisis to an objective national crisis is criminal. And it breaches every ounce of every rule of everything that the SABC is supposed to stand for. That's the point. As the court pleases.
Thank you, Mr. Mpofu.
Yes. Sorry, but just one observation that the reply was longer than even the argument to meet the main case.
I'm fully aware of that. Thank you, Mr.
Yes.
Mutau.
Malady, we've addressed all of this.
Doesn't matter, my lady.
Malady, I'm not going to address that. The only point that I'm making is your ladyship will take cognizance of the fact that I indicated that I departed from my prepared argument for purposes of accommodating the exigencies of the urgent court.
Thank you.
We've addressed all of these issues. They are in our heads, and we're not abandoning them.
Thank you.
Whatever I've said to have been conceded, and your ladyship will read the heads. We'll find no such concession. Thank you, Madam.
Thank you. All right. Judgment is reserved. We will adjourn until 2:30.
My lady, once again, we're indebted to the court and the court staff and my learned friend. Thanks.
All right.
Yes, for the next one.
Not for us. Okay, I thought it's reserved. Okay, sure.
No, we just stay out of your way. Thank you. I don't know what single case this is.
No, you see, now I can disturb it. Now I can tell them. When you start to tell them, I can disturb it. When you take it to a lady, I know that
Somebody told
You ready, Buta? Yeah.